If you've ever lived in an HOA, you probably know the feeling. A small disagreement that just starts to grow. But what happens when a long-serving board member decides the board itself has gone too far? Well, this is the story of one homeowner who decided to fight back by taking her own HOA to court. And this is Lisa Marx. After serving 3 years on her Arizona Condo Association's board, she was actually re-elected for a 4th term. But just 2 weeks later, she quit. That quote you see is from her testimony, and it really gets to the heart of why she launched this entire legal challenge. Her resignation, though, it wasn't the end of the story. Turns out, it was just the beginning of a legal battle that would put the very rules of her community to the test. So the battle lines were drawn. You've got a former board member and homeowner on one side, and on the other, the new leadership of the Terra Condominium Association. Now, this timeline is really important for context. Lisa Marx wasn't some newcomer who was just unhappy. She had years of experience on the board. She'd even been the chairperson. So her sudden resignation in January 2024, right after a new chairman took over, well, that set the stage for her to file a formal legal petition just a few months later. And we're not talking about just a casual complaint here. To officially challenge an HOA in Arizona, it costs money. Marx paid $1,000 out of her own pocket to file this thing. That's a pretty big commitment, and it shows you just how serious she was about these two specific issues. So what were these issues that were worth a $1,000 petition? Well, they really boiled down to 2 fundamental ideas about how an HOA is supposed to work: transparency and following the proper procedure. Okay, so first, she argued the board was illegally blocking her from seeing official records. And second, she said the board was making decisions and starting projects without ever talking about them or voting on them in open meetings, basically cutting the homeowners completely out of the loop. Let's look at the actual law behind that first claim. In Arizona, the statute is pretty clear. It says any member has the right to look at almost all association records, and the HOA has just 10 business days to make it happen. That's a really powerful tool for homeowners to keep an eye on things. And the second law is all about process. It requires that board meetings be open to everyone, that you get an agenda ahead of time, and, this is a big one, that members get to speak before the board votes on something. It's designed to stop a board from just making decisions behind closed doors. Okay, so we've got the battle lines and the laws. The case goes before an administrative law judge. Let's dive into the hearing and see exactly how each side made their case. For Lisa Marx, the argument was pretty simple. As she put it, being able to see these documents isn't about being nosy. It's literally the only way for a homeowner to make sure the board is following the rules for everybody. It's all about accountability. The board's defense was direct. They basically argued that as a regular member, she didn't have the right to see things like contracts. In one of their denials, they told her the reason was, and I quote, "You are no longer a board member." So for them, the key point was that her rights changed the minute she stepped down from the board. All right, on to the second accusation. Marx pointed to a bunch of projects, things like spraying weeds, spreading mulch, even refinishing some shutters, all being done by volunteers. Her argument was that none of this was ever put on an agenda or formally approved in an open meeting, which she claimed violates that open meeting law. And this quote right here, it perfectly sums up the board's defense. The chairman, Mark Gottman, testified that, yeah, they were a new board, and maybe they made a few mistakes, but he said it wasn't malicious. They were, in his words, mistakes of enthusiasm. Just a bunch of eager people trying to get things done, save the community some money, and make the place look better. So you've got 2 very different stories here, right? On one hand, a homeowner demanding that every rule is followed to the letter. On the other, a new board saying, hey, cut us some slack, our hearts were in the right place. So how did the judge rule? Well, the decision was split right down the middle. On the records law, the judge found the HOA was in violation. The reasoning was crystal clear. The board didn't provide records they had, and the excuse that you're no longer a board member simply doesn't hold up under the law. But on the open meeting law, the judge found no violation. The ruling there was that these small-scale volunteer projects like weeding and mulching weren't the kind of major actions that legally require a formal agenda item and a board vote. And the financial outcome reflected that split decision perfectly. The judge ordered the HOA to pay Lisa Marx back $500, exactly half of her $1,000 filing fee, because she won on exactly half of the issues she brought to the table. So, okay, that's the story of this one case.
But what are the bigger lessons here for anyone who lives in an HOA? What does this mean for you?
This case really clarifies a few key things. First, your right as a homeowner to see records is broad, and it doesn't matter if you're on the board or not. Second, a board's good intentions or their enthusiasm doesn't give them a free pass to break the law, but it also shows that not every little thing, especially minor volunteer work, has to get bogged down in a formal board vote. Really, the biggest takeaway is this: knowing your state's laws and your own HOA's documents is the most powerful tool you have.
And that leaves us with the big question at the heart of this whole thing. The board acted with enthusiasm, trying to do good, while the homeowner demanded they follow the rules. And you need both for a healthy community, right? So it makes you think, in your own community, where do you draw that line?